Thank you. Thank you very much for the kind introduction. I am the Executive Director of the Canadian Justice Review Board, which simply means that I'm the chief cook and bottle washer. The brains behind the organization are the directors, and in this case it's Mr. Bruce Haynes from Toronto, who spent a long time studying MPAC, at least for the last 10 years. His career in law spans about 35 years, but he's written a great deal on this subject, a lot of it which is posted on our website. Sorry, I'm not speaking loud enough?
Oh, I'm supposed to ask all three of you to please speak. That's not a mic,
oh, okay.
But it is, well, it's a microphone. It's not an amplifier, but our cameraman has asked if you could try to speak
into that more direct.
In that direction.
Very good. I'm sorry, so I hope you caught all that?
Not very much. That's okay.
The salient feature is that Mr. Haynes is a lawyer from Toronto. He has been our past chairman. For the past 10 years, he's been concerned about the way MPAC operates and the way assessments are done, and he's written a great deal about it. That information is more extensive than I can give today, but it's on our website if you care to go and read it. So today, in the limited time that I have, I'm going to try and cover 5 topics: the origins of MPAC, the relationship between MPAC and its employer, the city, the nature of the Assessment Review Board, a few things to consider when you're going to appeal your property assessment, and a brief outline of how to appeal. Let's see if I can get this to work. Some of you may remember that up until 1997, the province of Ontario performed the assessments, and it was operated through the Ministry of Finance, and the cost of that was covered by general provincial tax revenues, not by property taxes. But in 1997, the municipalities collectively incorporated what's known as the Municipal Property Assessment Corporation, or MPAC, and that organization took over property assessments in the province. MPAC is described as a non-share capital corporation, which basically means that all 444 municipalities are equal members or equal partners, if you like. The municipalities appoint the majority of the board of directors, and therefore they have control. For example, the late Ron Colbus, who was the councillor for Britannia, was a director. Peter Hume of Alta Vista has been a director, though not now. And the current chairman is Dan Matheson, and he's the mayor of Stratford, Ontario. The province has one observer on the board, and there are 2 so-called taxpayer representatives, but how they are appointed is something that I don't know. The point of this is to say that MPAC is not a crown corporation, and it's not part of the Ontario government. It's perhaps noteworthy that to distance themselves from the assessment process, a lot of city councillors like to tell you that it's not us, it's the province. Let's see, make it go. There we go. Since MPAC is not a government agency, the obvious question is who pays them and how much? And who has an interest in the assessment outcome process? The answer to that question is found in Section 12.1 of MPAC's charter. The amount MPAC is paid is determined by a formula shown on the screen. What you should be of interest to you is the letter C in the formula. The letter C is the amount of money MPAC considers to be needed for its operations. There's no upper limit. There's no apparent budgetary process. The other part of the formula determines the municipality's share. It's based on the increase in the assessment value in that municipality plus the number of properties in that municipality as related to all properties in the province, and it's the average of those, so divided by 2. Some of you may have noticed that your City of Ottawa tax bill has a line item that shows how much property tax goes to MPAC. Of specific interest to most people is how does MPAC determine value of your property? The Ontario Ombudsman looked into this matter a few years ago, and in his report, he described MPAC's methodology as cloaked in secrecy. MPAC claims to have a statistical method known as a multiple regression formula. This is a complex mathematical calculation that MPAC has refused to disclose even to the Ontario Information and Privacy Commission. The Auditor General of Ontario has said that MPAC's methods do not produce accurate results in 1 out of every 8 cases that the auditor examined. The Auditor General has found that in 1 out of 8 properties it examined, the assessment was wrong by 20%. But the law in Ontario entitles you to be assessed by real current value and not speculation. The law defines current value as the amount of money your property would sell for on a specific date. Most property owners own their land and their home, and this type of ownership is defined in the Act as fee simple. Now, there's a difference. If you own a condo, for example, you don't own the land under the building. So your ownership is not fee simple. And it's probably quite a mystery to me how MPAC assesses those properties. So what happens when you and MPAC disagree about the assessed value of your property? Your only recourse is to file an appeal with the Assessment Review Board of Ontario, known as the ARB. The ARB is a government agency with the power to overrule and change MPAC's assessments. Experience has shown that MPAC will not often budge from its position or modify its assessment unless it faces an appeal from you. Although the Assessment Review Board, or the ARB, is not a court, you should be aware that it has rules, and you must follow the rules, somewhat like the rules of court. The rules of the Assessment Review Board are intended to ensure that you get a fair hearing. Therefore, it's very important that you read the rules and that you understand them. If you don't know the rules, then MPAC can take advantage of you. If you don't know the rules, then you will not get all the information you're entitled to from MPAC, and you could lose on a technicality. For example, a lot of people don't know that MPAC must give you their complete argument 21 days before the hearing. If they don't, then you can protest, and then MPAC may not be able to make an argument or any presentation at all. It's important for you to know that you need to know what their argument is, and you need to be able to dissect it, and you need to have time to do that. So always ensure that you have it within 21 days. Let's see now. If your assessment is not correct, it may cost you thousands of dollars over 4 years, and that's money that you shouldn't have to pay. It's money you will never be able to correct because the mistake, once in place, if you do not appeal it, you are deemed to agree. So what might some good indicators or red flags be that might tip you off that maybe you should appeal? I've listed 5 of them on the screen here. First, your assessment has increased more than the average increase in your area. Or you purchased the property within months of the evaluation date for less money than MPAC's assessment, or you notice that similar properties were purchased for less. You notice that real estate listings for similar properties are not selling for the value MPAC has assessed. You notice errors in MPAC's description of your property. And the one that I hear about most all is your current assessment ignores the reduction you obtained in a previous appeal. And this is, I think, one of the features that aggravates most people. They spend a lot of time appealing, they win, the next cycle comes around, it's all forgotten. If it's less than, if you find it's less than the average, leave it alone. You have to remember that it's always historical. So the assessed value was for 2012. Most of the appeals that are going through now were up to 2014. So the value today is higher logically than it would have been in 2012. But you're only being assessed for 2012, and that will be phased in. The next cycle starts 2016. So the process for appealing is fairly straightforward. The first thing you need to do is to write to MPAC and request and write a letter of what's called a request for reconsideration. It doesn't need to be fancy. There is a form that's on the internet that you can use either on their website or ours, but you can write your own letter. You have to do that by March 31st of each of the years that you intend to appeal. So this year is passed. If you're going to appeal next year, you would have to do it for March 31st next year. Eventually, MPAC will reply to you, generally with a rejection, and it's at that point that you have the right to appeal, but not before. After you receive the rejection, the next step will be to file an appeal with the ARB, and you have to do that within 90 days of the date of that MPAC letter. If you miss the 90 days, you're out of luck. So filing an appeal is fairly simple. My preference is to go online onto the ARB website, and you do it electronically, and you can pay for it with a Visa card. The only wrinkle that I've seen on the ARB website is that there's some confusion about the date of the appeal that you're filing against. So, for example, 2012 would be actually 2013 tax year, and you just want to watch a few little technicalities like that. If you file in for the wrong year, you'll have to ask for an amendment later. But it's always the tax year that you're appealing, not the evaluation year. It's the following year. So for any of if you want additional details, as I said, Bruce Haynes has posted a great deal of information on our website, and you're welcome to go there and have a look at it. Before I discuss points 5, 6, and 7, I'm just going to click forward here, if I can. Too far. So this is an example of a request for reconsideration. I'm not sure if you can read it fully, but this particular lady and her husband bought a property on Lake Ontario near Kingston, and it's a peninsula that juts out into the lake. Nowhere on the peninsula are you far enough away from the water to get a building permit or a septic tank approval. So she bought the property with the intention of parking her camper trailer on there in the summer and having a summer home. So she paid $19,000. MPAC assessed her in 2012 for $78,000. So the structure of this request for reconsideration, she just says the assessment is too high, which is what you always would say. And here are the relevant facts. I purchased the property in March 2012 for $19,000. Here's my deed of transfer. Here's the legal description and the PIN number. And this is the law that applies to this situation. My purchase is the market value. And she quotes what is basically the seminal case, I believe, in Ontario, which is called Viva versus the Property Assessment Corporation, which went to the divisional court. And it confirmed that the Assessment Act intends that the fair market value is the price that you paid. And if you can establish that you bought the property pretty close to the assessment year, that should be the way it goes. Here's another example. Now this individual, they appealed their taxes previously, and they obtained an order from the ARB in 2008 establishing the value at $138,000. MPAC comes along in 2012 and says it's $321,000. This property owner looks around and he says, but the average in the neighborhood of all similar properties is 15%. Those are the grounds for that request for reconsideration. You don't need to put a lot of detail in there. You put the detail in at the very end. You just really, all you would need to say is it's too high and sign the letter. But if you have some compelling grounds that you think might get you a reconsideration without going for an appeal, by all means put them in there. I'll just back up again. So, going back now to points 5, 6, and 7, the key to success is to be well prepared. And this means collecting as much information as you can from realtors or from the MLS property listings of actual sales. It also means demanding that MPAC supply you with all the relevant information that they have, not just the 4 or 5 comparables that they may have cherry-picked from their database to support the assessment that they're trying to impose on you. Well, how do you do that? MPAC very seldom cooperates, but the ARB offers you the solution in its rules. For a lot of people, this seems to be a daunting task, but it's not really. On our website, there are a lot of standard forms, templates that you can pull up and modify to fit your particular circumstance. I'm just going to go forward now and see if I can give you an example here. So this is a notice of motion that Bruce Haynes filed in a matter in Toronto, and that's the basic format of it. You have your title of the proceedings at the top, you have who it's between, you versus MPAC, and in this case it would be the City of Ottawa, and it says notice of motion. And it says the complainant intends to bring a motion and he wants the following relief. The motion is for an order that the respondent provide details of the property assessment, and there's a whole list of things that he has asked for and was successful in getting. Now there's a second page in the middle that has the list of things that he wanted, and at the conclusion you put the grounds for the motion. They're always the same grounds. It's the Statutory Procedures Act, the ARB rules, and Section 19 of the Assessment Act. You sign it, you file it up, you send it off, you appear before the ARB, and you ask the ARB to order MPAC to give you the information you require. Now, this sort of, I'm segueing into my next topic here. This is a long, rambling letter that somebody that this organization knows received from the lawyers who represent MPAC. You probably can't read it from there, but the relevant paragraphs are up in here, so I've cut and pasted them into this slide. And so this lawyer says to this fellow, I'm a lawyer, and I have been retained by MPAC to address the issue with respect to your representation of owners of this property. Well, the big problem here is this fellow is very successful at representing people, and he generally has been winning. So they say to them, they tell him, you are neither a licensed lawyer or a paralegal with the Law Society of Upper Canada, and although my client has indicated to you the need to be either for the purpose of representing the parties, and I'm sorry. So it carries on. He's not going to do it. So they're telling him that he's been warned. So what's the truth or the reality here? Well, Rule 9 of the Assessment Review Board, and this is why it's really important to know the rules. It says representatives who are not licensed by the Law Society of Upper Canada must obtain written authorization and may be asked to provide this authorization to the board at any time. If representation changes, the party and the representative shall immediately notify the board and the other parties. So the bottom line is there is no requirement for the representative to be a lawyer. That was a up the valley word, eh? A lawyer, a paralegal, or to have any association whatsoever with the Law Society of Upper Canada. And MPAC has a lot of other, my colleague calls old tricks or sly tactics. As I've mentioned, you're entitled to 21 days notice of their argument. I sit into on a lot of hearings, and there was a lady there totally unaware of this. And I mentioned to her, I said, well, do you have their information package? Well, no. You didn't receive it 21 days ahead? Well, no. In the back of the room, of course, are the MPAC assessors. And they go, hmm? So one of them comes running down to this girl, and she says, well, I emailed it to you. And she says, I never got it. Well, that's like the check's in the mail. So this assessor pulls these people naively out, and they went off to into a back room, and I'm sure there were some high-pressure negotiations and veiled threats going on. One of the veiled threats that MPAC likes to use is, if you don't agree today, we can reassess your property higher. They can't actually do that. The Assessment Act forbids them to reassess it higher. It can only be in the following year, the next cycle. They can stonewall you. We have a fellow in Toronto. He's been writing incessantly to MPAC for the information. I just don't answer. As I said, they like to get you into the ARB hearing before you're ready. They do this all the time. They're always ready. But an unprepared property owner is easy to overcome, put it that way. And they will take advantage of your naivety. So it's important that you know the rules. So here's what the Auditor General has to say about MPAC's bureaucracy. Our review of a wide variety of travel, meal, hospitality, and other expenses noted a number of examples that appeared questionable. Our specific comments are detailed as follows, and you can go and look at that for yourself. But basically, they're partying on the taxpayer's dime. It's a big bureaucracy, and there is no budgetary process that I've seen to control it. So, in short, there's a quote here from the Ottawa Citizen, and it says, the Provincial Auditor's Report into the Municipal Property Assessment Corporation's management is 18 pages long, but it can be summarized in 3 words. They are incompetent. Some of you may know that the Ombudsman, Andre Marans, looked into MPAC several years ago, and he came out with quite a scathing report. This is his most recent report. It's up to date. It's 2012-2013. And he's still documenting complaints that he gets. And now I've abridged them a little bit to fit on the screen here, but he's quite humorous the way he puts his titles. So he calls this one Death and Taxes. And he says the Municipal Property Assessment Corporation had unfairly assessed a funeral home that it had previously exempted. As a result of inquiries from the Ombudsman staff, MPAC officials agreed to reimburse for the taxes paid in those years due to their assessment. Then he has another one, Wet and Wild. A woman complained to the Ombudsman that after requesting a reduction in her property assessment from MPAC and from the Assessment Review Board, she argued that she was unable to use a large portion of her land because it had been zoned as protected wetland. The Ombudsman staff contacted the Land Program Director of the Ministry of Natural Resources, who confirmed that the land in question, called low and wet, could result in a reduction. And eventually she did get one. So the question is, don't become, I guess not the question, the point is, don't be complacent. The squeaking wheel gets the grease. Now, at the bottom of his many comments, he's pointing out that one complainant had submitted a single request for reconsideration to both notices. She said MPAC's customer service staff had not told her otherwise, and as a result, she was unable to appeal the values in the assessment change notice. The second complainant was in a similar situation because he mistakenly believed the March 31st deadline applied to both notices. Although both were given information on how to appeal their assessments to the Assessment Review Board by MPAC, the Ombudsman staff brought the cases to the attention of the senior MPAC officials so they could avert future complaints. So what you have to take from this is you need to educate yourself. You need to understand that MPAC is paid by the municipality, it works for the municipality, it doesn't work for you. And they really don't have any interest in seriously helping you bring an appeal against one of their assessments. MPAC should be always regarded as your adversary in an assessment dispute. The ARB, on the other hand, is similar to a court. It makes decisions based on the best evidence and tends to side with taxpayers more often than not, and I'd put a caveat on there, when you're well prepared. The rules of the Assessment Review Board are available to you for your use, and you should take advantage of them. And you can read the rules. Mr. Haynes has prepared a summary that I've given in a handout here. They're also posted on the ARB website. Bruce has given an interpretation of the rules so that a layperson can better understand what needs to be done. So I hope that's been some help to you. If you, as I say, if you need some more information, more detailed information than I've delivered today, you can have a look at what's posted on the Canadian Justice Review Board website, or you can email in any questions that you have. Now, I mentioned in the earlier presentation the views of the Auditor General that the MPAC is not a very efficient organization. And this, I hope, will segue into Jack McLaren's presentation on what else might be done. So I'll turn it over to you, Jack.
Okay. Listen, I have posed a question.
You have a question?
I'm in the middle of preparing a package.
Yes.
Basically a submission to the board for meeting at the end of May.
Okay, now just so I'm understand, to MPAC or are you into the appeal process? Okay.
I've gone through the other parts of the process.
Okay.
My question is this. I think I have a fairly persuasive argument in my own favor, of course. But I wonder, is the ARB empowered to instruct MPAC to freeze the amounts forever, or like on a continuing basis, or are they just going to keep coming back at the end of 5 years?
There's probably somebody else here who can speak better to that than I can, but my understanding is you can obtain an order freezing your assessment for the 4-year cycle. On the next, when it comes back in 2016, it's a new game.